Good morning, everyone. Today is October 9th, 2025, and this is an agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben. I'll take the role of the other commissioners who are present for the hearing. Commissioner Partridge.
Here.
Commissioner Sullivan.
Here.
Commissioner Tuma.
Here.
A quorum is present. We have just one item on our agenda today. Mr. Bonet, please introduce the docket for us.
Good morning, Chair, Commissioners. The item before us today is docket number G-022/GR-24-350 in the matter of the application of Greater Minnesota Gas Incorporated for authority to increase rates for natural gas utility service in Minnesota, and docket number G-022/GR-24-351 in the matter of Greater Minnesota Gas Incorporated's petition for approval of a new base cost of gas. The parties are present and have been notified that they will have up to 10 minutes for opening comments. However, before I turn it back over to you, I do have a couple of housekeeping items. The first one is that new decision options were e-filed yesterday. The parties have all affirmed that they've received it either virtually or have a hard copy. If anybody in the audience wants a hard copy, there's hard copies in the back of the room. Second item is I do have a couple of minor corrections to the briefing papers. They do not impact any decision options, but just to clarify the record, if you go to volume 3 on page 30 of the briefing papers, down at the bottom of the page, this section is the department's recommended edits to ALJ findings in their exceptions to the ALJ report. At the bottom of the page is listed finding 154. The department recommended that finding be deleted. However, the briefing papers do not show the strike through, so that is the change on that page. Similar edits, if you go to page 36 of the same volume, you'll see, again, this is the department's recommended edits to the ALJ report in their exceptions. You'll see in the middle of the page 163A, that is new finding that the department proposed. That should be underlined and in being read, as well as ALJ findings 164 through 167. The department recommended those be eliminated, so those should be strike-throughs. Those are the only edits that I have at this time, and as I mentioned earlier, neither of these corrections impact the deliberation outline or decision options. With that, the parties and staff is available for questions. Thank you very much.
Thank you very much to our staff who worked on this. We'll begin with opening comments, and I believe we'll begin with the company, and then maybe after we're done with about 30 minutes of opening comments, we'll take a short break and proceed to, the intention is to go kind of volume by volume as we make decisions and do questions. So if that sounds good, we'll get started with Greater Minnesota Gas. Good morning.
Good morning, Madam Chair. Madam Chair, Commissioners, Eric Swanson from the law firm of Winthrop and Weinstein on behalf of Greater Minnesota Gas. Also with me is Chris Cerny from our firm. And then from the company, we have Greg Palmer, the CEO, Cody Chilson, the president, Robin Berkey, CFO, and Christine Anderson, who you all know well. It's a pleasure to be here today. We may be a small company and it may be a small rate case, but it's a really important rate case for the company and for our customers. This is only the third rate increase that Greater Minnesota has sought in its 21 years now of being a state rate regulated utility, and it's our first case in 15 years. I think you're all aware of the background of Greater Minnesota Gas, but I want to highlight just a couple things before turning to the issues. GMG was founded to provide service to areas that previously didn't have natural gas service and were relying on either propane or heating oil. And throughout its history, GMG has been funded by individual investors that live in those communities. These are individuals who have never received a dividend. Instead of paying those dividends, the company has reinvested in its service. And the record shows that that reinvestment has paid off in exactly the way GMG hoped, that it saved its customers significant energy costs over the years. The record shows that actually if you retroactively applied the interim rate increase to January of 2019, over those 6 years, GMG has delivered savings of 50% in energy costs to its customers compared to had they needed to stay on propane or heating oil. The company's really proud of that accomplishment, proud of the fact that they've been able to stay away for 15 years and done so with a workforce of 25 total employees. If we turn to this case, as streamlined and as bare bones as the company attempted to make this case, it was still actually the most robust filing the company's ever made. Given that Ms. Anderson is both the entire regulatory staff and the entire legal staff, the witnesses were the CEO, the president, and the CFO. Judge Palmer Denig looked at the testimony, carefully considered it, reviewed the full record, and the company supports her findings. We recommend that you adopt decision option 1, and of course there are other decision options that you may want to discuss and that may be added. And now I think the most important thing that I have to say today is this, that you can adopt decision option 1 and you will do no damage to any of your precedent. The judge carefully considered the facts of this case in light of your precedent and came to reasonable decisions that will result in just and reasonable rates. So I want to highlight a couple of those for you and explain why I can make that statement. First, there was an issue about retention agreements, referred to as long-term incentive, but that's really not what these are. These are retention agreements, plain and simple. For certain key employees, GMG encourages them to stay with the company because we need them to stay with the company. After 3 years, they receive an additional award if they're still with the company. That's it. There's no financial component whatsoever. There's no other incentive. It's you're still here doing good work for us in 3 years. We're going to recognize that. And that's critical for a company the size of GMG. This is just completely different than any other similar compensation program you've looked at. To the extent you need to make specific findings to clarify that, we have no objection whatsoever. But this is critical for the company. Second one I'd like to discuss is the sales forecast and first-year residential customer sales. Judge Palmer Denig, again, accurately summarized and analyzed the record, its findings 168 to 194. And I'd particularly highlight findings 170 and 171. The company, in its test year forecast, has forecasted historically high sales. The company hasn't lowballed its sales forecast. As Judge Palmer Denig noted, though, because of the business model of GMG, the company tends to add customers early in the year during the construction season. Those customers don't take gas at the start of the year. They take gas beginning in the fall, and that pattern repeats itself. You can look back and see year over year, it's the same thing. The department suggests that we should impute a full year of revenues for those residential customers because they'll still be on the system next year. That's true, they will, but next year the company will also be investing in new customers who won't take gas at the start of the year. What Judge Palmer Denig's recommendation recognizes is that we've captured a representative test year without imputing revenues that simply don't exist. And if we do that, we're going to under-recover our revenue requirement. Again, it's just a different fact pattern than you typically see. There was also an issue about meter sets. accounts 381 and 382. We actually spent a considerable amount of time comparatively on this issue in the hearing. And again, we think the judge got it exactly right. She saw it for what it was. There was a clerical error that was made. That's unfortunate. It happens. But that clerical error doesn't change the fact that when you look at those two accounts combined, the numbers make perfect sense. There's a slight increase from 2023 to 2024. There's a slight increase from 2024 to the test year of 2025. The judge didn't penalize GMG for making a clerical error, and we encourage you to follow her lead on that. Finally, on ROE, as with all of GMG's rate cases, we did not hire an outside expert witness. Instead, we provided the testimony of Mr. Palmer, who in a prior life was also CFO of the nuclear management company, so has some expertise in the area. And the reason we didn't hire an expert is pretty simple. We try to keep our expenses as low as we can because it has a disproportionate impact on our customers. As we noted in our exceptions, for example, related to some of the requirements that have been suggested, just a $50,000 cost, which would be really cheap ROE testimony, a $50,000 cost on a per customer basis for GMG would equate to a $4 million cost for CenterPoint. Those are costs that we chose to avoid. We do think, nonetheless, you've got a record here that shows that GMG's request is entirely reasonable and, in fact, conservative. We did not ask for an increase in the ROE. We asked to leave it at 10. The Department 2 growth analysis showed in direct testimony a mean average of 10.5. By surrebuttal, that had gone up to 10.68. That's the method you've historically relied on. We're coming in 68 basis points below that. We think that's reasonable and conservative and ought to be adopted. We'd note that even including the flotation cost adjustment, we're still then at 10.15, a very conservative number. To get to something like the department's recommendation, you have to put significant stock in the department's multi-stage DCF analysis. And with all due respect, we don't think that's a bridge you want to cross in this rate case. It's an interesting theoretical debate that's occurring in other rate cases where there are fully engaged experts with very different views. If the commission is ever going to pivot away from what has been 15 years now of reliance on one method, we respectfully ask that you save that for another rate case. And then the other issue that took up a lot of oxygen, and I won't spend time on it because we really appreciate Commissioner Tuma's decision options related to the CCOSS. That did get a lot of debate, but we can discuss your decision options, Commissioner Tuma. We appreciate them. We do have a couple concerns that either I or Mr. Palmer can explain, but we think that's on the right track on that issue. And that's all I have for now.
Thank you, Mr. Swanson. I'm not sure who we said would be next. Is this the OAG, Mr. Cherney? Welcome. Please state your name for the record.
Good morning, Commissioners. Joey Cherney, appearing for the Office of the Attorney General Residential Utilities Division. I'll try to keep from making weird noises. Okay. It's a start. This case is fundamentally about the burden of proof. By law, the utility bears the burden to prove that a change of rates is just and reasonable. And this makes sense because the utility is the gatekeeper of all the information it needs to prove that a rate increase is necessary to cover the costs of providing service. And what that standard means is the utility must prove for each of its costs both that the cost is necessary for the provision of utility service and that it's just and reasonable for ratepayers to bear that cost. And by law, any doubts have to be resolved in favor of consumers and not the utility. And the burden of proof and legal standard apply to all public utilities, regardless of size, regardless of where in the state the utility operates, and regardless of who the utility serves. These are just a basic part of the regulatory compact that folks agree to follow when they decide to go into the public utility business. GMG has failed to meet the burden of proof for several aspects of its requested rate increase. I'm going to focus my time on two issues that we raised that I think particularly well illustrate GMG's failure to meet its burden, but of course we continue to support all of our positions in our exceptions to the ALJ's report. So the first issue I want to address is our recommended modification to the sales forecast. So this is different from the one that Mr. Swanson talked about in his opening. This is about the small commercial customer count. As the Commission knows, a utility's sales forecast is central to setting just and reasonable rates because the number of customers and the estimated usage have a direct impact on forecasted revenues, which are compared to projected costs of service, and the difference gets you the revenue deficiency. So GMG selectively chose its customer counts, which ultimately improperly inflated its proposed revenue deficiency. For its sales forecast, it first forecasted that it would only add 400 residential customers. And then from February 2024 through the entire test year, it would add no small commercial customers at all. But when GMG said that in November of 2024, it had already added dozens of small commercial customers, not zero. And when the OAG's witness pointed this out, GMG then said in rebuttal that the 400 residential customers actually included small commercial customers. It just didn't break the small commercial customers out because it doesn't break them out when it plans to expand its distribution system. But a rate case sales forecast is not its expansion plan. It's a forecast of revenues that gets baked into rates and that doesn't change until the next rate case. The particular usage patterns and revenues from different customer classes are crucially important for the sales forecast. So by including small commercial customers in the wrong customer class in the sales forecast, GMG improperly increased its revenue deficiency. And rather than making a reasonable change to the forecasted customer count in rebuttal, GMG instead argued that the entire sales forecast should be redone by updating to actuals to increase its revenue requirement by $92,834. However, this is crucial also. GMG conspicuously did not redo any of its costs of service, meaning it only wants to count the reduced revenues from serving less customers, but not count the reduced costs from serving less customers. And this means that GMG is proposing to use data most favorable to it from two different data sets in order to increase the revenue requirement as much as possible. This is illogical to use data from two different data sets, and it does not meet GMG's burden of proof to provide a reasonable sales forecast of sales. So we therefore recommend using the forecasted test year customer counts in GMG's initial filing to ensure revenues and costs in this case actually correspond to one another, but then also increasing the small commercial count from 946 to 990 to reflect GMG's incontrovertible growth in that class. So another issue that highlights GMG's failure to meet its burden is its request for organizational dues. A long-standing commission policy is that a utility should not recover dues amounts that do not benefit ratepayers. Makes sense. Nevertheless, GMG argued that it should recover its full dues expenditures for the American Gas Association and the Minnesota Agri-Growth Council, including amounts for lobbying activities and despite showing that they provide no benefit to ratepayers. When the OAG observed that GMG did not remove any amount from its dues request for lobbying activities, GMG insisted that it had removed amounts for lobbying, even though the receipts it provided clearly demonstrated it hadn't. As for ratepayer benefits, when the OAG asked for evidence of ratepayer benefits from the AGA and the Agri-Growth Council, GMG made general statements that these organizations provide beneficial services or even that they might provide beneficial services in the future, but it didn't produce any actual evidence that these organizations currently or will certainly provide beneficial services. These are just a few examples of the many times that GMG insisted on unjust or unreasonable positions, even after interveners demonstrated empirical inaccuracies in GMG's representations. And these discrepancies were never reconciled, and so on those issues, GMG has failed to meet its burden. That's that. I thank you for the opportunity to address you all this morning, and I thank you in advance for taking care to weigh the evidence and thoughtfully apply the burden of proof that the legislature has dictated. And I am available to answer any questions and talk about preferred decision options.
Thank you, Mr. Cherney. And Ms. Arnold, welcome.
Good morning, Chair Sieben, Commissioners. Catherine Arnold, Assistant Attorney General for the Department of Commerce. With me today are my colleagues Amrit Hundal, and from the department, Nancy Campbell, Craig Andonisio, Michael Zychek, Sachin Shah, Donald Hirosuna, and Dr. Sidney Lieb. I'd like to start by thanking Commission staff for the thorough briefing papers. There was a lot to cover, and the department appreciates the briefing papers' recognition of not just the parties' positions on various issues, but the relevant evidence from the record. As described in the department's arguments and exceptions, there were many places where that information was glossed over or outright missing from the ALJ report. Before I highlight a few of the most critical disputed issues in this case, I want to address how we found ourselves in a situation where everyone has spent far more time and resources than they would have liked to on a rate case for the smallest rate-regulated utility in the state. Given the amounts of money that are often at issue in matters before the Commission, it's easy to look at some of the recommended adjustments in this case and ask why we have an entire room of trained professionals spending their time on these disputes. When we were all here last December to discuss the company's initial filing, you heard from GMG that it hoped that this case would be resolved as quickly and informally as it had in its last case. The department sincerely shared that hope. Despite a busy calendar for the first half of 2025, filled with not only the usual rate cases for other utilities, but also proceedings on resource acquisitions, certificates of need, an imprudence cost recovery case, and the little matter of a $6 billion proposed acquisition of a utility, the department took GMG's request for a speedy process to heart. Although the statute provides a 3-month extension in such circumstances, the department worked out a schedule that used only 10 extra days. GMG nevertheless opposed that request. The department developed that schedule relying, in part, on the same representation that GMG repeated to you at that December meeting, that GMG was an open book and would work with the parties to streamline the process and avoid unnecessary regulatory expense. The reality was far different. As the department noted in its written comments on completeness and at the December hearing, its initial review of GMG's filing only assessed whether the required material appeared to be included, and nothing of its underlying merits or quality. When the department began reviewing the contents of GMG's filing, it soon found that basic information was missing and basic concepts were misunderstood. The department did its best to secure the information needed for a rate case using discovery. Even though it's not the department's burden to develop a record supporting a rate increase, the analysts assigned to this case worked hard to turn what was filed into a functional record that can be used to set just and reasonable rates. While GMG provided meaningful responses to some of the department's inquiries, which in turn frequently led to the parties reaching an agreement on those issues, GMG responded to many of the requests with the taciturn reticence that would be expected during a cross-examination, a far cry from GMG's promise to be an open book. On other issues, the company's discovery requests revealed serious inconsistencies with the contents of the company's initial filing and subsequent rounds of testimony. For example, in rebuttal testimony, GMG provided an itemized list of changes the company made to its class cost of service study. Yet in discovery, it admitted that it had also removed an enormous amount of projected consumption. Given the tight deadlines in the case, a schedule that the department made in good faith after GMG pledged to be cooperative and resolve issues efficiently, the department did not have time for additional follow-up before rebuttal testimony was due, or the evidentiary hearing which took place just a few days later. I want to be clear. The department does not oppose an increase in GMG's rates. The department's goal is to set rates at levels that are just and reasonable, no more and no less. When GMG asked to update their rate base for gas storage costs by more than $200,000 midway through the case, the department said yes. We agreed to that adjustment because GMG provided a credible explanation for the increase and sufficient detail to verify that explanation. When the department has said no to something that GMG has asked for, it is because the request was improper, factually unsupported, or both, such as GMG's request to add flotation costs to its existing equity, for which it has already expensed the cost of issuance. On many issues, GMG did not provide support for the size of the requested increases in the rate case or in its response to the department's discovery, instead providing information for the first time in its rebuttal testimony. For example, when the department sent GMG an IR asking to explain why there was nearly a 50% jump in its repair and maintenance expenses, GMG's response only said that there were, and I quote, increased expenses. It wasn't until rebuttal testimony that the company shared that it had needed to sign contracts with new vendors for a variety of services that were 23 to 33% higher than previous costs. GMG has emphasized time and again that it is a small company with few employees and that even high-level employees regularly get involved in the nitty-gritty details of running the company. The type of information the department was asking for in discovery wasn't arcane details that would need to be tracked down through layer upon layer in an org chart. It's information that strains credulity to think wasn't readily available or in fact already known to the very employees who were providing responses to the department's requests. As I noted earlier, some of the financial adjustments still at issue in this case seem small, and perhaps for some commissioners, raise the question of why the department is using resources on disputes of that size. There are a few points that I think need to be kept in mind for someone who is asking themselves that question. First, as GMG noted during the completeness hearing, it is approximately 1/100th the size of some of the utilities that come before this commission. That means each dollar of adjustment has roughly 100 times as much impact on a GMG ratepayer as it does for a customer of one of those larger utilities. Second, GMG's size is so much smaller than other utilities that it can still leverage increasing economies of scale in a way that is unavailable to larger utilities operating in developed markets. Even though GMG last increased its rates 15 years ago and set them at a level that was only expected to produce a return on equity of 4.24%, since that time, GMG has only had a single year, 2011, where it earned less than the ROE its rates were set to capture. In contrast, despite all the inflation that has occurred since the last set rates, GMG has had years where it earned nearly 12% ROE, including a 5-year stretch over which its earned ROE exceeded 10%. The two largest issues before the Commission today are the company's ROE and its sales forecast. For return on equity, GMG argues that the Commission should rely on a two-growth DCF model that puts the cost of equity before any adjustments for GMG's size or any other risk factor between 10.68 and 11.12%. Those numbers are completely out of line with anything the Commission has authorized in the last 15 years. The Department's recommended 9.56 ROE gives GMG a significant increase over the ROE the Department has recently recommended in other cases, accounting for GMG's small size and the illiquid nature of the investment. The Department's expert explained why many of GMG's claimed risk factors would be inappropriate to incorporate into its ROE, such as the fact that investors can mitigate weather-driven sales volatility by diversifying their holdings. As another example, not paying out dividends, but instead reinvesting in the company has grown the company's rate base 4 times what it was in the last rate case, enhancing future payouts to shareholders. The Department's explanation for why these alleged risk factors should not be incorporated into ROE are unrebutted, and the ALJ's report incorporation of those factors in setting ROE should be rejected. On sales forecast, GMG is asking that its test year be adjusted to reflect lower than expected sales without any changes to reflect the fact that many of its actual 2024 expenses came in notably lower than the projections the company provided late last December. The request asks the Commission to functionally abandon the test year concept altogether. Test year expenses and revenues should reflect a normal year. The Department's proposed sales forecast provides a normalized year that we would expect to see going forward, and is in alignment with adjusting test years for known and measurable changes. In this case, customers that will continue to stay on the system and take service from GMG. The Department appreciates the opportunity to present these remarks and is available for any questions the Commission may have.
Okay, great. Thank you, everyone. Any questions or Mr. Turner, you mentioned it, but are there any corrections to the briefing papers or your position in the briefing papers that you wanted to make? Or if any other party did?
I think it's probably best to do it contextually at volume by volume, if that makes sense.
Sure. Okay. Anyone else had any changes to the briefing papers or the party's recommendations that you wanted to flag now?
Madam Chair, we can do it as we walk through. That's fine. There are a couple minor corrections. I do have what I think is an important correction that I need to make at some point to a statement from Mr. Cherney.
Okay, why don't you do that now?
Mr. Cherney represented that the company did not ever adjust for lobbying expenses. That's not correct. And I would just draw you to ALJ findings 262 and 271. Lobbying expenses were removed.
262 and 271, the ALJ findings.
Correct.
Mr. Cherney?
So those were not introduced until a briefing after the evidentiary record had closed. And what I was talking about in terms of the insistence that they had removed things that they hadn't was everything, all testimony and the evidentiary hearing. And then, once council reviewed things and wrote the briefs, they said, okay, we'll remove $157 for one of them, and I'd have to look at the numbers for the other one.
Any corrections from the department on the briefing or on the decision options that you wanted to flag now? Otherwise, we can handle it as we go through.
I think it makes most sense to handle things as we go through.
Okay.
Just two quick clarifying questions. Are they in or out right now, Mr. Cherney? Are the lobbying expenses in or out?
In the ALJ's report, the expenses that they say are lobbying related are out.
Out.
Out, correct.
What? Okay.
We dispute whether that actually covers all of the lobbying expenses.
Got it. Okay, that's helpful. And then the other, Ms. Arnold, I just want to clarify a point that you made, that you said the company has made its, you said between 10 and 12 ROE for, did you say the last decade, or what was the number?
Yes.
Could you just repeat that?
So there was a 5-year stretch where if you average the ROEs over that period, it was exceeding 10%, and there were 2 years where it was nearly 12%, and that was in a table in
Yeah, that,
rebuttal testimony. We do have that flagged, and I believe our arguments and exceptions, the citation, I can track that down if you're interested.
when we come back, if you just have I just want to take a look at it. Thanks.
Okay, let's take a 10-minute break and we'll come back at about 10:45 a.m. Commission stands in recess. Commission will come back from its recess, and we'll start with questions or comments on Volume 1. So Commissioner Tuma, did you want to begin?
Madam Chair, I will. It's kind of interesting. I was tallying up the major issues each of you announced, and I pretty much agree with all of you. And so we're done. But I know that you differ on some of those major issues that you laid out. The first one, I think, that I find important to deal with is incentive pay. So I am jumping over a few, and I want to go to incentive pay. I can tell you, I agree with your long-term assessment. That makes perfectly good sense. I get what your company's doing. You have long-time employees, and one of those employees leaves. It's a big problem for you. So that one I can buy into without any problem. The annual incentive pay, though, we've had a long-standing standard, and we try to avoid every rate case is its own rate case. And so there'll be a few decision options we work through to try to avoid turning GMG into a Mr. Swanson citing it in a center point or an Excel rate case. So, but I do see incentive pay as important. We do know that at least some employees, I think you would agree, Mr. Swanson, do shareholder, I guess, for lack of words, you don't have shareholders, but investor interaction, keeping them informed, keeping them up what's going on. I know they don't get dividends and all that. I appreciate that. I mean, I understand what's happening here. At some point, those families are going to die. They have a trust, and it's going to go to their kids, and they're going to stepped up value. So they probably are okay with their other businesses giving them dividends now, and they're going to get all this value you've built into that. And it's a good business model that you've developed over the last few years. And so I have no problem with the fact that you have to keep them informed. They're aging. So when you put in your testimony, Mr. Palmer, that they're aging, I get what you're saying is that at some point, those next generation are going to have to make a determination. Do I keep the money in there, or do I ask it to be bought off, and how does that look? And that'll take some of your time, or whoever is there at that time, some time to do that. And so we've had a kind of understanding that what does that look like? Okay, we'll talk a little bit more about when we get to flotation, but in this situation, it would seem to be the case. I think the reasonable solution at this stage, because it's different than Centerpoint or Excel or those, is to look at this case in its unique sense to say, we got to consider something. And so when we looked at the numbers, this is a number that came to my mind, and our staff kind of ran through a number to say it's 25%, okay? And the result of that, my understanding, Mr. Swanson, if we say that in this rate case, essentially there'd be no disallowance because there is not 25%, but there would be, and the implication is that we anticipate there will be some time, and that there should be an accounting for that for this one employee, okay? So I run that by you to say if we would change 110 from 15 to 25, do you agree with that conclusion, okay, that it's not going to have an impact on this rate case on what the revenue requirement is? And two, would that be something the company would be okay with?
Mr. Swanson.
Yeah. Madam Chair, Commissioner Tuma, thank you. And thanks for sort of sharing your analysis and thought process as well. First, on the implication of the 25%, you're correct. There is one employee, as you noted, that does have a portion of his pay. The president has a portion of his pay. And yeah, the company does hold an annual meeting of its shareholders. The company would not object to imposing a 25% cap at this point, given the unique circumstances of GMG. Yeah, we had opposed the adjustment in its entirety because there was also testimony that neither Mr. Palmer nor Mr. Chilson nor anyone else spend significant time on shareholder concerns. They just don't. But I think your solution is a reasonable one going forward. I would ask that decision option, if you go that route, I'd ask that decision option 112 not be included to require GMG to file an annual compliance filing evaluating the operation and performance. That seems a bit of overkill at this point. Might it someday be appropriate for a company like GMG? It might, but right now we'd ask to be relieved of that burden if you do put a cap in place.
I kind of did a list of what I thought would be good decision options, and that wasn't on there for that very reason. And our order writer can kind of handle the substance of what we're doing. But if it looks like it's a problem and we're seeing all your investors are dying and you're struggling to get investors, I would assume you're coming for a rate case or something, and we would deal with it at that stage. So
Madam Chair, Commissioner Tuma, I think we're on the same page.
to the OAG and DOC. Looking for some middle ground here. Like I said, it seems like we can work through some of these issues. That seems to me to be fair to recognize at least there's that one employee that's doing that, and we can deal with it down the road. Any problems with changing 110 to 25%?
Chair, Commissioner, thank you for the question. The department believes that the 15% cap is appropriate, but it's not going to give us too much heartburn if we change that to 25% here. Our ask would be that in the order, there's some clear articulation of specifically why it is applying in this case, so that we don't, again, have to be wasteful of regulatory resources in other cases, arguing with every utility thinking that that's meant to apply to them as well.
Yeah, and I think our order writers are aware of that. I don't think we need to get in the detail why. I mean, I think that's articulated well enough in the briefing papers of what the reasoning is. So, Mr. Cherney, any concerns?
This one's a department issue, so I defer to that.
Well, good. Moving on, like I said, I talked about long-term incentive. The other one, that's the big one, so it's kind of jumping forward a few, but it is the 381, 382 meter issue, okay? And yeah, decision option 120, 119, 120, that's correct. And so, in my understanding, that's a OAG issue, okay? Mr. Cherney, you've heard their argument. I want to kind of just get back to you. I read the order. I saw what the judge did, combining them and said it's a modest increase, okay?
Commissioner Tuma, you read the ALJ report?
ALJ
Or-
report,
okay,
yes, sorry, I should have called ALJ order. ALJ report. And looked back at the record and said, seemed kind of reasonable to my, backwater attorney mind, okay? But I also want to understand, do you disagree with that as factually inaccurate, or is basically your argument, this all came late, burden of proof, they shouldn't benefit? I'm trying to understand the essence of your argument.
Yeah,
Mr. Cherney.
You would disagree with the ALJ.
certainly, Chair Sieben, Commissioner Tuma. So it is an issue of the burden of proof, and it's specifically the burden of proof to prove that that adjustment for AMR meters actually exists. So the tables that I think help illustrate this are not in the briefing papers. They're in our exceptions at page 29.
And 19?
29.
29. And is the argument essentially is that, yeah, you can see that, but there are other adjustments that we're not are able to put into consideration? I'm not recalling those. I read your exceptions, but they're not jumping out of my brain. So
the issue is that, GMG said that it made this accounting error, and the number that it should have put into one account should have been put into
Yep.
another account. But our question was that number, the $176,834, where does that come from at all? Like, do those meters exist? And they said, well, look, regardless of which account we put it into, the total outcome is the same. And we're saying, but, the total outcome isn't the issue. It's where did the predicate number come from? And we never got any answer about that. The other thing, it's just a plug. So like what happened in their initial filing was they said they would need $747. And then in the update, they said, well, their year-end actuals had been reduced because of this clerical error. But then they maintained the outcome number of $520,747. So and that's the figure 2 in our exceptions. They just added in the $176,834 without any justification for why it should be there.
So that would be the adjustment, would be 176K down to the basically what the revenue requirement would be based on their failure to show exactly where all that came from is the argument.
That would be the average rate base, not the revenue requirement. The actual revenue requirement, it gets calculated separately, like what impact that has on it.
Oh, okay.
But and what GMG said was, well, this is all a function of not having updated any of our test year costs to actuals. But that's essentially an admission that, they gave us what their end of year 2024 actuals were, but didn't adjust any of the test year. And had they adjusted it, it would have gone down. So
this is a fair proxy of what you feel it was a better representation of their actual
exactly
base rates.
And we feel that the rate base and we feel that 176,834, we just never received any evidence that those meters exist.
So Ms. Arnold, I'm going to ask you, but I'm actually asking, and you're looking back exactly where I want to ask, but I don't want to ask somebody that through their attorney. I would cherish what Ms. Campbell thinks about this, because you were not listed as, on the briefing papers dealing with this issue, but I do look to your department as kind of the rate case accountant types. He advocates for the small residential, and he's doing a good accounting argument. I just want to know if this is something they agree with or disagree. It just would help me out.
I appreciate your recognition that I'm not the right person to ask about accounting issues.
It's us attorneys. Attorneys math, as we say.
Ms. Campbell, welcome. Please state your name for the record.
Nancy Campbell with the Department of Commerce. This issue is really about, can the company justify this adjustment, in my view? So I kind of do defer it to OAG, but I will note that, for the revenue requirement, it's probably about 10 to 15% of that 176,000. So it's probably only a $20,000 adjustment roughly to the revenue requirements, if that's helpful. But
I was thinking it was the full amount. That's helpful.
Yeah, I do think it's a little problematic that it did seem like it was a plug number, and it didn't seem like GMG provided support for it.
That's helpful. Mr. Swanson, obviously you're going to want a chance to respond, and I wanted to give a chance to respond. But
Thank you, Madam Chair, Commissioner Tuma, and I'll preface by saying the person who made the error that we're talking about is in the room. So if you want to talk to Ms. Berkey, she can explain exactly what happened. But I would draw your attention to ALJ finding 284. The way this became an issue at all is that the company was asked to provide actuals for these accounts for 2024. The company discovered an error. As Judge Palmer-Dennig noted in 284, because the company only adjusted one column, in addition to providing 2024 actuals, it provided 23 and 25. The company only adjusted one column. That's where the plugged number comes from. It isn't a plugged number. It's the forecast for the combined accounts 381 and 382. In hindsight, what the company should have done was adjust all three columns, and then this never would have been an issue in the case.
Well, it should be an issue here, sitting here and asking someone to come up and explain the mistake. I mean, that's parts that I think is frustrating for the commission as we're sitting here, and you have the burden of proof. And there is question in my mind, and when that's the case, the statute says what?
Madam Chair,
Rate
Commissioner
ca-
Tuma,
rate case decisions
I
need to
think
go
the
towards
company
the-
met its burden of proof
Well,
on this.
I know what you're saying. I'm just frustrated
And
that we're here
and I-
talking about.
And Madam Chair, Commissioner
$20,000.
Tuma, we are too. We should have answered that information request differently.
I don't know if other commissioners, I want to go on to something else, but if others have questions on this, since it's one of the bigger ones. Let's go to the little one then. Okay, dues, okay. Here's where I'm at, okay? I look at the dues, and frankly, I just want to say, the American Gas Association and the Agri Council, let it go. I do somewhat agree with you on the charge for the rates for when you go and argue cases in front of FERC, I guess, or wherever you're making the arguments. That one made good sense to me, okay? But it also, I understood the argument that was being made, we don't do this. And so in our briefing papers, and I went back and looked at the record, and so it seemed to be accurate, but missing a little bit. It mentions that you had for that $1,100 a year estimate of what you pay for dues for this association that you argue rate cases in front of, that I believe it was 2021, 23, and 24 that you paid dues, okay? And if you use our 5-year average, that's more than 1/3, and that's what the AOAG was saying to cut it, okay? My question to you, was there dues paid in 2020 or 2025? So far, all I know is there wasn't dues paid in 1 year over the last 4 years.
I'm going to turn this one over to Mr. Palmer. And again, we appreciate the recognition. I mean, this one is an important one for the company just because Northern's rate case alone has the potential to impact our customers by almost $2 million
I
a
totally
year.
agree. There's no
So,
question in my
yeah,
mind.
we appreciate
I'd
that.
be surprised about that. It's just the question about what should be the appropriate amount. We've already burned through that money already by talking these last 2 minutes, so.
Madam Chair, Commissioner Tuma, sad but true.
So Commissioner, what the fees for that group are to pay an attorney in Washington.
I know what the fees are for. My question is, you pay
And
dues on a sporadic basis.
We paid in 2025. It's highly unlikely that Northern's rate case will be settled by December 31st. And it's highly likely, if anything is contested, there will be dues due in 2026. We also participate with some of these members on Viking rate cases. So it's driven by rate cases.
I
They're
understand it.
multi-year.
So if we were to do that, I mean, you don't pay it every year, but you pay it quite often. So it's more than 1/3. I was trying to come up with a number. And so 4/5 would be 880. And so that's what I was going to suggest. And again, we burned through all that money talking about it, but here we are, and we got to make a decision. I was so proud. I was talking to my staff. Oh, we can do this. Oh, I just saved the ratepayers $400 or something like that. So I mean, I get it. So would 880, if we just put that in there, would be 4/5? Is that fine?
That's fine.
Okay.
Commissioner Tuma, I didn't quite track that. What decision option is
So
that?
118, we would just change that so that the number instead of 365 is 880, and be 4/5 as opposed to 1/3.
And that would be the dues for what?
For the MRGTF, which is an attorney they hired to represent them at FERC to keep rates low
That's
out
not-
of the Northern Pipeline.
Okay. And then
And I was going to ask the
you were,
department.
okay, go ahead.
I think
sorry.
OAG made the objection, so.
Mr. Cherney?
Chair Sieben, Commissioner Tuma. One thing that the ALJ report didn't say, it said that they paid 4 out of 5 years. It didn't say that in 2021 they only paid half. It was $550. So that's it technically would be less than 80/20, but it's 80/20 is fine.
Yeah, I mean, it should be something less than the 11, which is, I think, a fair proxy. That's what they paid last. That's a fair proxy going forward. So that was my thinking. And Madam Chair, if your other question is on 117, my inclination is to deny both of those, but that's what I was thinking, but I wasn't going to ask any questions on it. But if you want to ask questions,
No, that's what I was thinking, but I didn't know what you were thinking.
that's what I was thinking.
For
Commissioner
the record, that
Sullivan?
was my follow-up question, 117, because that's what I'm thinking too.
Okay,
I did have another question, but we can, whenever you want.
go ahead.
I guess I wanted to go back to the larger, the larger disallowance for the bookkeeping error. And my question for the OAG and maybe the department is, if this is, as the company claims, just a bookkeeping error, what would you have been looking for to be okay with this that you didn't get? And I'm not trying to shift the burden onto you, but I'm just honestly trying to ascertain, like, what didn't the company do?
Yeah, so,
Mr. Cherney.
sorry, Commissioner Steven, Commissioner Sullivan, Chair Steven, Commissioner Sullivan. What we were looking for was evidence of that rate base, like the existence. So there are certain meters that go into FERC account 381, certain that go into 382, and they said that, oh, well, we just, put it into the wrong account for depreciation purposes. Or one of the things they talked about was group depreciation. And we said, wait, we're not talking about group depreciation. We're saying, like, where are these meters? Where is this rate base? How do we know that it actually exists? Especially when, the outcome of making this adjustment is to just keep the higher overall test year.
How would you have, say they hadn't made the bookkeeping error, and the number would just have been in there, how would you have looked at it any differently? I mean, like, I would think you'd be like, okay, that's the number, and that's the number, we'll work from there. But the counterfactual is what I'm posing, like, what if they hadn't made the bookkeeping error, how would you have verified it that you weren't able to verify?
We wouldn't have known to look for it. And this goes back to the whole thing about, like, at the end of the day, the utility is the one who has access to all of the information. And there are going to be things that regulators, we really rely on, transparency. And so had the error not happened, we wouldn't have known to look, so we wouldn't have gotten into it.
No, that's helpful and fair, and I guess to the company is, how can you respond to Mr. Cherney right now in the department?
Madam Chair, Commissioner Sullivan, the same way I responded before, we made a mistake. And in hindsight, we should have answered the information request differently. And I think everyone would have seen the meter set numbers are consistent for 2025 as they were for 2024.
Don't they have that information now, though? Like, don't they have?
It would have been an issue. I'm sorry?
Don't they have that information now? Like,
Madam Chair, Commissioner Sullivan, we could have filed a revised information request response when it became apparent that we weren't being understood. I don't know what else we could have done. The meters are the meters. I mean, we have these dollar values in those accounts, and if we aren't allowed to include them in rate base, we have meters that aren't included in our rate base.
So, Mr.
Because we
Cherney or
made an error.
Ms. Arnold, like, what is that? I'm honestly just trying to figure out, like, I don't want to punish the company with a pretty significant, punishment if there is a clerical error, but I'm also like, look, the process is important and it leads to better outcomes over the course of, the process, and it's better to be, consistent and do a good job. So, like,
Right. So, Chair Steven, Commissioner Sullivan. So it's one of the so he was saying that they could have updated their IR response, and I think that's the key thing is that you asked, what do we have the numbers? We don't have any of that. We requested the information, but we weren't ever given any proof. So all we have to go on is a statement that it was a clerical error, and we're saying we weren't asking about the clerical error. We were asking about.
Prove it out for me.
Yeah.
Prove it out. Okay.
Can I interject?
Absolutely.
Mr. Cherney, so you believe though that what I have heard is that the company, that $176,000, you're saying like prove that those actually bought meters that were placed in service, correct?
Essentially, or prove that those meters exist because those are meters from an older time. But yeah, prove that they're there.
And what I heard the company say is they just put that $176,000 amount in the wrong line of their FERC accounting table, but the meters are installed, and they are like were an actual cost incurred in 2024, correct?
Well, but we don't know.
You're saying you don't
There's
know,
never any-
there's no proof that they actually spent that 170-some thousand on meters that are now installed. And so, Mr. Swanson, I hear you when you said like you installed the meters and it was just a accounting error for where that, but how are we supposed, is it if you add up like those line numbers of meters and meters installed or installations, they are all add up to the same number we're talking about. So doesn't that show that the meters were installed?
Madam Chair, it does. And again, if it would be helpful, I don't know if it would be, but Ms. Berkey is happy to walk through what happened in the books and why we're here talking about this. But the meters are there.
And Mr. Turner, you're shaking your head no. So one more chance to try to explain. I get they screwed it up and the burden is on them.
Right.
But
and-
it kind of seems like, and the judge agreed that I think the judge found that that was the explanation, like it was an error.
Right. And,
Not that the meters are missing.
Right. And again, there is nothing in the evidentiary record about that. And the fact that the numbers add up at the end is a function of the test year costs, none of the test year costs being updated when we asked for actuals. So
But that was 2024 and the test year here was 25.
right, and so the ending balance for 2024 affects the average rate base balance.
Yeah, but if you add those two lines up, then you get the 2025 test year number, right?
So you would, can I maybe ask Nancy to explain?
Sorry, now I'm getting confused. I'm not confused. I just think I don't understand.
Yes, no, it is.
Oh,
You're
and
right.
sorry, and I just want to note that the reason I'm asking Nancy is that Shua, our accountant, is out, so she can't speak to this. But
So, Ms. Campbell, I'm looking at the Mr. Cherney summary of rate-based component adjustments updated with 2024 actuals that Mr. Cherney, cited earlier, that's in their exceptions. And I think I heard you earlier say that, like, overall, this has a negligible effect. But I think it is important, to Commissioner Sullivan's point, like, we have to get the actual spending right to arrive at the proper test year number. But it seems like if you add those lines up, you get the adjustment total correct for 24, which would feed into the projected 25 test year.
Why I agree with that, I think my concern is regardless of whatever year that $176,000 increase is, to me, the company should have been able to show something to support that that's appropriate. Anytime you have an increase of 176,000, to me, you have to provide something, and they had opportunity.
But
and
isn't that
information.
their filing, from their FERC account filing, where you add up the numbers and then get the meter
I know,
number?
but like if we see an increase of 176,000 to an account and as OAG did, they sent an information request, to me, the company needs to respond
Yeah.
and provide adequate support, and they haven't. That's why we're doing it here.
Yeah, the only disconnect, I get that it was sloppy and they made an error and then they didn't correct it when they should have corrected it. I think the evidence, though, is the judge saw the evidence and sided with the company still and said like it was an error and this is where there's enough stuff in the record to explain why the meters aren't ghosting us and are really there and installed, and I don't know.
You know, I guess I just kind of more focus on what I think is now the more important issue that came out of it is they have a $176,000 increase to their meters and they haven't justified it, so.
Yeah, I get that, but I think the meters are there.
So they say.
So everyone says, but I don't know. Commissioner Sullivan, sorry if I overtook you there.
No, that was good and that was helpful, and I appreciate that you kind of followed on from there because I thought that was good to dig deeper on there. I mean, is there something that the company could do right now in the public hearing to say these meters exist, they're on our system, they are an actual cost, almost like an affidavit or something? It feels to me like if they actually exist and the company attests to that, does that answer your question, Mr. Attorney? Does that answer the company? I mean, and believe me, I understand the point and I agree with you. Like, the process is important. And everything you said, Mr. Cherney, about, like, got to get this done right the first time. There's an imbalance between knowledge so I get all that and I agree with you. And we have to make a decision on it too. So, but like, it feels like this is a river that can be crossed in the moment. Mr. Swanson.
Madam Chair, Commissioner Sullivan, two things. First, there isn't a $176,000 increase that's unexplained. There was an error that overstated one account by that amount and understated the other account by that amount. Unfortunately, the company didn't carry that through each of the columns in an answer to an information request. But we will do whatever you need to attest that the meters exist. They're there. They're serving customers.
I think the number is there. It's just it was put in the wrong line.
Yeah,
And
I think so too.
I don't
yeah.
know why. I don't.
Maybe I'm just
I'm fine.
over-indexing on it and overthinking, but I mean, like,
I
I do think to the company, like, it was sloppy. But you've already admitted that. I mean, I don't need to kick you in the stomach, that much, but like, do better. And I think that's the point that the OAG and the department have raised, and it's like,
It comes down to it. There is a burden of proof element here. You don't be bringing these major adjustments at the last thing. We don't do a testimony here. We don't swear you in. That's what we do ALJs for. Now, the ALJ sided with you, okay, but we also have to assume that there's an argument there that we didn't have all the information and it wasn't available to us in a way that we could verify whether they do exist or not. I mean, this is stuff that's happening after, in my mind, somewhat after the ALJ made their determinations. And so we're stuck kind of with a difficult decision because of it. But, well, we don't need to spend more time on it.
No, we might be disagreeing on that one, Commissioner Tuma, but that's okay.
That's fine.
Yeah,
Yep.
I don't care.
I'm not too worried about it.
I care, but
I do have
I'm
some.
very accommodating lately.
I do have some
Of
minor.
disagreement between commissioners. That's what I'm saying.
Oh, I do want to just the minor ones, and they're 130, 131A, 132, 133, and 134 of the decision options. They're uncontested. My view that most of the uncontested don't need to be done because the ALJ has addressed them in their order. These 5 were not addressed in the order, but were discussed somewhat in the record prior to the ALJ order and also and later in exceptions. 131A seems to me to be something that is a decision we would want to do. Okay, at least that's what my staff tells me that we should do, and they want to do 131A. I want to give you a chance to say, no, we don't need to do that, it's already dealt with, or whatever. So it's the base cost of gas purposes.
But, and Commissioner Tuma, just to clarify, doesn't 131A mean they wouldn't adjust the base cost of gas in this docket, but it would be adjusted later? That's, okay.
And so, Mr. Swans, any concerns with that?
Madam Chair, Commissioner Tuma, no, we're indifferent on those.
Now, 130, 132, 133, and 134 were not addressed in the ALJ's order and substance, but my understanding is that all of that is already built into what would be the revenue requirement. And so whether we address it or not, whether she addressed it or not, is really irrelevant. It's once we've kind of come to a final determination of what the revenue requirement is, we don't need to do any of those. We don't need to clutter our order with them. We can save our order writer the headache of putting them in the motion and dealing with them in the order. Is that your understanding?
Madam Chair, Commissioner Tuma, yes, I think the reason they weren't addressed is just that they were resolved financial issues, but you don't need to address them.
So my motion, if I do make a motion, okay, would be not to include anything essentially after 121 on, because I don't think we need to address the income tax rider, because I don't think we're dealing with it, and nobody thought it was a big issue, and I don't think it's either. So from 121 on, I don't think we need to do any decision options other than 131A. Does the department agree with that assessment?
Chair Sieben, Commissioner Tuma, sorry, I maybe misheard you. Were you saying that you would take decision option 121 and not 122?
No, I would just not do them. Just, there's no need to do them because they're not really discussed in the order. No conclusion was made, and I don't agree that we should do it. So.
Right, yeah, the department does not have any concerns with that, and the department favors option 131A over 131.
Mr. Cherney, do you understand my thinking?
Yeah, no objection.
That's all the questions I have on the first volume, Madam Chair.
So Commissioner Tuma, that's helpful. Can we, could you make a motion?
Sure.
And then we'll just make sure commissioners are tracking before we vote on it, and we might need to break out that one issue if you want.
Yep. So, Madam Chair, if I were to make a motion, which I can do, but this is my thoughts, would be to do number 2, okay, which is adopt the ALJ's order, okay, with whatever modifications necessary based on what we do. I would do 102. I agree with the department on the truck expense. I would do 103. I agree with.
And sorry, you do both parts, A and B too,
Yes.
in 102?
Yep.
Okay, sorry to interrupt.
No, that's okay. I would do 103. I agree with the company on education. I would do 106. I agree with the department on postage. I would do 108. I agree with the department on maintenance. I would do 110, but modify 15 to 25. I would not do 112. I would do 113. I agree with the company on long-term incentive. I would not do 115. I would do, 117, where I just would deny recovery from the AGA and agriculture, but I would change 118 and change the $1,100 to $880.
Okay, hold
Oh,
on.
no, excuse me, I would change the 367 to $880, and I think you could probably just delete the 3-year period results and just say 100, allow them to recover 188 for those dues.
And for 117 and 118, you'd take the subparts as well.
Yes, the subparts of 118 would probably not, because they would have to be adjusted, so I would not do 118 A, B, and C. The order writer would have to do her magic. But 117 is fine.
117, you would do the
The changes, yeah,
A,
B and C.
B, and C, is that right,
Yep.
Mr. Bonnet? They're consistent if you did all three of them?
Yep, I think
Okay.
they are.
And then, sorry, and then are you just stopping for there?
Nope, I got one more.
Or
Well,
did
actually,
you
a
have a
couple more.
question on that, Commissioner Sullivan?
I just wanted to make sure that I heard Commissioner Toomey, you would do 113
Yep,
and then 115,
I would not do.
116, not do it, and then 117.
A,
And,
B, and C.
and you would do 117, A, B, and C. And then I also wanted to clarify 103 or 104. I thought you said you would do 103, the department. I thought department was 104, but maybe I misunderstood or misheard you.
103, the,
ALJs and,
103, the company, yeah.
okay, I misheard you then.
And then Commissioner Tuma, in 118, you would strike 1,100 and replace it with,
That was incorrect, Madam Chair. I would strike
oh,
367 and replace it with 880. And then just take out the language of the 3-year or 1/3 or whatever it was that in there, just say,
so it would say, order GMG to amortize the total MRGTF dues of $880 result, or no, of,
No.
why don't you read it for us? Because it's not working in my brain.
okay, that's okay. So 118 would read, order GMG to, I don't know, words collect is right, but it would be to, instead of amortize, that's where you're getting confused, and I
To
didn't notice that
collect
till
a
now.
cost of $880 to be included in the test year?
Yep, something along those lines. Yeah, I thought this would lend itself to a quick fix, but it doesn't, so, but allow them to recover $880 of the MRGTF dues.
And then we won't, and then not adopt A, B, or C because it will be modified a little bit, or the order
Modified by
writer
the
can.
Order writer, yes. Then next is the meters, 120. I was persuaded by the ALJ, but I think we should just pull that out and make a decision separately, because it seems like there was some different discussion. So why don't we not do 119 and 120 for now?
Okay,
And then I would say, just do decision option 131A, and that would be minus the FERC account one. That would be all of the decision options for financials.
so commissioners, I wasn't listening closely enough to Commissioner Tuma. I thought you were supportive of 120 in the FERC account?
I was, but I think there was, I heard this, so I thought we'd just separate that discussion and do that one
Oh, okay,
separately
okay,
and just deal with the other ones
okay.
now. That's my thinking, but
So Commissioner Partridge and Commissioner Sullivan, if we put Commissioner Tuma's motion out now, first, are you clear on what that is? And then, do you have any questions about it? Or want to discuss it? Is the motion clear to Ms. Kaler? And the parties, you don't, okay. So on Commissioner Tuma's and Mr. Cherney?
Yeah, I'm sorry, Chair Sieben. For 117 A, B, and C, I just want to clarify something. This was an issue that I made. A, B, and C is intended to basically say replace the ALJ's findings with the OAG's findings. The way that A is written doesn't quite do that, because my bad, I changed some numbering. So, like ALJ finding 258 and OAG finding 258 don't directly correspond to one another. So I just wanted to make clear that A, B, and C, it's clear that the intention is to say we have to change the findings in order to support 117. I just wanted to highlight for the order writer that doing exactly what 117A says would wind up with a couple of order points that are repeats. And
So let's just
What
not
if we,
do A, B, and C.
let's just not do A, B, and C and let Ms. Kaler write the order consistent with our decision, which is to deny recovery of those portions of the dues. Does that work?
That's a good
Okay.
way to go.
Thank you for that. And then any other clarification things on the motion? So commissioners will take a voice vote on Commissioner Tuma's motion. All in favor, please say aye.
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 Opposed, the motion prevails. So Commissioner Tuma, we either have to choose between 119 or 120. I understand the burden of proof issue and how this is messy, but I just think in the end, we're gonna end up in a better spot if we pick a better representative test year amount. So I support 119. But if you want to move 120 because of your reasons, we can
No,
just.
I don't want to move and lose. I would rather just, know what, if Commissioner Sullivan or Partridge are of that same mindset. It really is not a big one for me either, so.
Commissioner
Can I ask-
Partridge.
So I just want to recap my understanding. Okay, so I'm not sure who, I'll ask the company and then maybe the department or the OAG to confirm. So my understanding is that there was a clerical error where a number was put in the wrong column, in the wrong account, and there was a correction made to say, okay, $176,000 should have been in this other place. Here it is. And then the OAG said, okay, then basically show me your receipts. Like, where are these things? And then the company responded to that request with a conversation about depreciation, which was not responsive to the question you asked. And the company has acknowledged that. And now your argument is we never got the receipts. And you guys are saying, but you also said we never would have asked for the receipts had they not made the error, right? Yeah,
because
right.
it tends to be that sometimes errors are what highlight an issue.
Right. Okay. And then the company is saying we either didn't understand the IR or we were juggling too many IRs, whatever the issue was. We responded incorrectly. Nonetheless, these meters are in customers' homes and businesses today, fully operating, functioning, and you're going to have to pay for them one way or another.
Madam Chair, Commissioner Partridge, that's pretty much it.
Okay.
The only addition I would make to that is we did note when we answered the information request that led to all of this, that we specifically noted we hadn't adjusted other columns, which the judge also recognized in her findings. But on the basics, you've got it accurate.
Okay. I am leaning towards, I agree that it is your burden of proof, but to Chair Siebens' point, if we know that the meters are out there, then undercounting the total cost that the company is going to need to recover doesn't really benefit anyone and just leads to deficiency, and we're all back here very cranky about the next rate case. Not that anyone seems cranky, but so I think I'm leaning towards 119.
Madam Chair, I would move 119. Because I didn't want to get a tie vote, Joey. So if you're siding with me,
I mean, no, I appreciate Commissioner Tuma, your thinking on this, and I appreciate where the OAG is, and I mean, everything Mr. Cherney said, I'm like, yeah, I understand, and I mean, but at the end of the day, I'm kind of like what Commissioner Partridge just said. I agree with that. This is one of those things now that I'm almost at year 6 of my term where I'm like, there's so many little things that could just be nipped in the bud. And this is one of them.
Yeah.
And we've spent a lot of time on this, and I think that the OAG and the department are kind of, they're right, like in principle. But I also look at, like I think this would be, it's a clerical error, it's pretty clear. This is pretty knowable, and I think it would be, we know that they're there. So I think it would be unfair to not allow recovery. So I'm supportive of 119, and I just reiterate what I said before. It's just like, come on, this is the stuff that is easily resolvable in discovery.
Madam Chair, I renew my motion.
All those in favor of 119, please say aye.
Aye.
Aye. Opposed, the motion prevails. Okay, moving on to the sales forecast. Who would like to start with questions? And this is obviously, there's some things that were said in the opening statements, or did you want to begin? Do you have Commissioner Tuma, can you walk us through what your new Tuma 1217 is, please?
Madam Chair, there is a theme in this section and the class cost of service section about we don't want to go back and look at an order from, 2005 or something like that. So my goal here is to try to capture in this order, okay, all those issues that would be relevant for a future rate case. And so my thinking along this lines was we would adopt 205, 209, 211, 213.
Wait, you were saying what? 205?
209, 211, 213. Then I asked my staff what's missing, and they came up with 217, which is the new TUMA 217. Okay. And then if we would do that, then we would do 215, which is only the first sentence of 215, which is said that we're not going to make you go back to prior rate cases. I don't want to make our new executive secretary have to try to figure this all out, so I'm trying to do it in our order and not do something after the fact. And so my hope was, don't go back to the old rate cases, but here are the things that are necessary going forward. And so I guess to the department and OAG, since I'm trying to wrangle this together, and I'll be perfectly honest with you, a lot of this was staff help me out here, okay, after spending 3 weeks trying to understand BlackRock acquisition of $8 billion or whatever it was we came up with in the end, trying to figure this all out. So I have to say my brain was a little stressed on this. So I will just repeat it again. 205. So the new reporting requirements that will be needed if we go away would be 205, 209, 211, 213, and TUMA new 217. Thoughts, concerns? If you need some more time, feel free, because I'm wide open on this one.
The department would support this option. Thank you.
Mr. Cherney.
I'm cross-referencing here. We're okay with that as well.
To the company.
Madam Chair, Commissioner Tuma, I wish I could say we're okay with
Kind
it.
of figured you probably wouldn't. because
Really
you-
appreciate the effort and
You
really,
you oppose some of these, so I figured there would
yep,
be.
really appreciate the discussion and the ability to work through this and so that we all know what ground we're standing on going forward. I think I'll ask at the right time, Mr. Palmer to address 205 and 217. On your new 217, A, B, E, and F, we can do with our new billing software, but I'd ask Mr. Palmer to explain the challenges with C and D and with 205. I wanted to address 213. That one does give us heartburn. With GMG, we don't know 9 months ahead of time when we're going to be filing a rate case. To protect the company, we'd probably want to meet then every year. We just don't know that that one's workable.
If you just said, meet with the department prior, are you okay with that? Just so that you have a pre-meeting and it's coming, and most of the time you do this anyways.
Madam Chair, Commissioner Tuma, that would be fine.
Because there was some problems. I think you'd have to admit there were some issues. We were under the impression this was going to be slam dunk settlement. We'd be in here with an ALJ order saying approve the settlement. So,
Madam Chair, Commissioner Tuma, completely agree and think that's a reasonable resolution.
any problem just saying that? I know it's to say the sky is blue, but I guess maybe it's making a point. I don't know.
Thank you, Chair Steven, Commissioner Tuma. The department thinks it is important for there to be a meaningful period of consultation and provision of feedback and actual incorporation of that feedback before the next rate case. Everyone in this room has acknowledged we don't want this many resources to be put into a GMG rate case. They have a small number of ratepayers. But the discussion and the concerns that came up just in that discussion of the meters, that wasn't an isolated issue. That wasn't a one-off concern. Those are all throughout the entire case. And, there's some pretty significant errors. There was IR responses that acted as though the department or OAG didn't have any business asking the things we were asking. And given that GMG frequently likes to have these cases completed as quickly as possible, right? This was a tight timeline. There were only, 3 weeks between the rounds of testimony. We jumped right into the evidentiary hearing. This was very difficult, and no one wants to be in here and say, we have to make guesses about what rate should be because we don't know. Trying to establish facts at this stage, it just does not work well. And if you had asked us before this rate case happens, I think we would have had a lot of confidence that we could work with GMG in a reasonable way without more parameters on there to get to something that is workable, that's fair to ratepayers, that provides the record we need. What we have experienced in this rate case has stripped away every bit of that confidence.
Yeah, and that's unfortunate. I think we scolded them enough at this stage. I mean, I don't know how much more I can scold them and what I write in an order to tell them don't do it again. We're going to assume they're going to probably be back in sooner than they were the last time. They were making it off on all their commercial, those big, large hog farms and turkey barns they were connecting, was able to give them that kind of success. Doesn't sound like that's going to be happening soon in the future. So they're probably going to be back here. So the memory will not be lost. Hopefully the memory muscle of 4 or 5 years from now, they'll remember this. I can see where it gets a little difficult further down the road, but I get what you're saying, but I'm not too stuck on 213. I get what it's there for. You didn't do your job, and so. Sorry, Madam Chair, I got into my soliloquy on that one. So, you have some more stuff, though.
Madam Chair,
213,
Commissioner Tuma, yes. If Mr. Palmer could address both 205 and then Part C and D of your new 217.
Madam Chair, Commissioner, thank you for allowing me to talk. 205, as it's written, seems simple. And if you have a concentrated market that is in one part of the state, it's relatively easy to pull county economic data and growth rates for counties and things like that. What we have is slivers in probably 15 different counties in Minnesota where we have run natural gas to large agricultural users. 40% of our market is agricultural food producers. And then we serve the residential customers adjacent to those. We are in a couple of larger communities like Mankato, but that is a small part of our total market. And so when you start to run economic data, and that was the trouble, the OAG witness was a professor from Houston. He was used to running economic data from government information and provide econometric models on why the growth rate was right. It didn't make our forecast more correct. The judge looked at our forecast in finding 171 and said, you've run sales forecast higher than any sales in the company's history. It's 10% higher than the 6-year average that you've achieved, and it's 25% higher than you did in 2024. The company's forecast is reasonable. And we are criticized for not putting in a lot of econometric models and data, but the information we have doesn't apply to the market we serve. And that's the problem we have with number 205 is you're asking to spend money on an analyst that can put in this data that won't make the sales forecast more accurate. It will make it less accurate, but we'll be able to talk about our models and whether or not they're right. And that's the company's objection to that.
I get that, Mr. Palmer, but you're going to pay for it anyways, because you're going to pay for that guy from Houston or wherever to do it. If you had done it in advance, you might have avoided having him to feel like he needed to go hire an expert from Houston. So
the issue on number 217 is we can pull items A, B, E, and F out of our data. We have 3 markets now, as opposed to the 2009 rate case. All of our market was south of the Twin Cities. We have 3 distinct areas in Minnesota that we serve. Detroit Lakes, around Little Falls, and south of the Twin Cities. Each has different degree days and data. So what the request is that we will manually pull multiple degree days each day off of data sites to match it up with the billing cycle so we can provide manually prepared Excel files to run regression models for sales. And that is a tremendous additional workload for the company. If we go to the software provider to provide it, they don't do it for anybody else. We're going to have to pay to customize that software to put that data in. When we provide you information on weather normalized sales for the JAR or for the different financial reports, we use monthly or annual degree day data. What this is asking for is a daily input so that you have the right degree days in each billing cycle. And if we don't provide it, the next time I'm before the commission, you will say you didn't do what you promised to do. So we're just making you aware this is a very extensive effort.
So you're promising something, okay? You just said you can do something. So what can you do on weather normalization? Maybe you might make Mr. Cherney happy.
We
So
can
tell
put
us
in
what you
an annual weather normalized data for each of the 3 markets on the file and match that up. Annual weather normalized data isn't every day. It's not by every billing cycle. It would just be a standard weather deviation number for the class, because that's what's done in the JAR that we file with you in the different reports.
Mr. Cherney, I don't know. I don't go and worry about these models every day. So he's apparently telling me I'm telling him to do daily, have somebody at their staff daily record the temperatures. Not my intention, okay? So I don't know what I'm asking here. Like I said, my brain's not like married to any of these things. But I agree, weather normalization is an important part of rate making, okay? So am I asking him, or you asking him, because it's both 205 and my 2217, okay? Am I asking him for daily, have somebody at their office daily go out and check the temperature?
No, you're not, and we're not asking for anything they shouldn't be able to do in-house. You know, they do weather normalization in their gas jurisdiction. Actually, also real quick, need to correct the record on our expert. He's an economist who works for us. He had moved to Houston by the time of the evidentiary hearing to pursue his PhD. So we didn't hire an outside expert.
So it's in-house.
Not a professor. It's in-house.
Arguably, they're going to be paying for it because you're going to bill them for some of your time, I would assume, but that's.
The OAG actually does not bill the company for any
Okay.
of our
There you go.
any of our work. But you know what? Maybe I will have Ms. Hinderly discuss the weather normalization in a little bit more detail.
Thank you, Chair Sieben. Catherine Hinderly, Assistant Attorney General for Office of the Attorney General Residential Utilities Division. I don't have a ton of background on weather normalization. I just kind of wanted to explain why we are where we are. So Mr. Stevenson is pursuing his PhD, so he's no longer employed by us, so we don't have the details. But I can say he was able to do all of this in Microsoft Excel, I believe, with pulling data sets from public sites, I think operated by NOAA. So I don't think we're asking for a ton. We're not asking for GMG to go out and do temperature readings themselves. I don't think that's something that other utilities do. I believe that there's publicly available temperature data that can be used for this
Is that the
process.
same information he was, oh, sorry, Madam Chair.
No, go ahead.
Was that the same information he was getting on the economic development? Could we just maybe have you guys go in the back Birch room for a few minutes and come up with a decision option that you all can agree on, so that I don't have to sit here and ask dumb questions I don't know any answers to?
Well, I think, Ms.
I was just, Chair Steven, Commissioner Taylor, we're certainly happy to work with the company on economic development data. I don't think that it suits anyone to be using data for sales forecast purposes that is so unique that it's potentially inaccurate. So I think what, we would be looking for is economic development data that is available from likely the federal or state governments. So.
And is what you're asking in 205, Ms. Hinderly, is it requiring weather normalized sales for different regions of GMG's customer base that was just discussed, or is it weather normalized data for all of GMG's service area? Because Mr. Palmer made it sound like they'd have to do different regression analyses for their different service areas. And that seems like a lot. But if what you're asking for, which I thought it was, is just weather normalize your sales, like other utilities do, like I didn't think your 205 was anything out of the norm.
Chair Sieben, Commissioner Tuma, this is reaching the limits of my knowledge on it. There is 3, I believe, GMG service areas, so I don't think, if that's the split up, it's not too much. The department also reviews forecasts, and so I would want to make sure that their sales forecasts
Are you asking for 3 different weather normalized areas in your 205? Because this is your decision option, correct?
I don't think we specified it, Chair Sieben, so.
So you're not asking for 3 different areas?
We could do 2 things here. Okay, one, we can require in a compliance filing with negative checkoff, some sort of discussion to determine what is the appropriate filings that you would got between now and the next rate case. Okay, or we can have you guys agree with it right now and tell us what that would look like. Either one just works for me.
Chair Sieben, Commissioner Tuma, unless Mr. Shaw from the department has something to add, I think we're comfortable with anything that puts us in a better position than we were in this rate case. So I think weather normalized sales from our perspective for the full region is fine, but I don't want, if the department believes some more, specific data is needed, even though this is our decision option, I believe that they also had testimony on weather normalization that I don't want to ignore.
Mr. Swanson?
Yep, Madam Chair, Commissioner Toomey, you were reading our mind over here. Rather than try to put something together here today where we still might end up, unfortunately, having misunderstandings, it'd be our suggestion that you just require the company on the issues raised in 205 and 207, require the company to meet with both the OAG and the department and come back to you, hopefully with an agreed upon, if not, a clear written menu for you to choose from. But my hope would.
C and
D.
D, you're okay with the other ones, right?
Correct.
217.
217, it's just C and D that we'd separate out, and then 205 we'd separate out, and just gives us time to work with everyone and make sure that we can actually get on the same page. And if for whatever reason we can't, obviously you'll tell us what to do.
I don't understand why, maybe I'm just getting frustrated here, but 205A is adopting the OAG's proposed findings 1 through 5. And my question for the OAG then is, are you asking for anything, what are in your findings 1 through 5 that isn't normally in sales forecast where you weather normalize the sales?
Yes, we are not asking for anything that is not normally in a weather, in a sales forecast.
And not divided out by their 3 separate areas.
That's right. We never specified anything
So-
about 3 separate areas. We just,
I don't, Mr. Swanson, like, you're objecting to 205A, I heard, and I don't think I don't understand why.
Sure. Thank you, Madam Chair, for asking for the clarification. The particular concern is that the demographic and economic variables, it's not the weather normalization on that one that is a concern. It's, as Mr. Palmer said, we tend to serve small slivers of these communities, and using countywide data that is readily available, that is what Mr. Stevenson used, just presents a very, very distorted picture. It doesn't get us closer to an accurate forecast. So that's our concern with 205. It's not the weather normalization.
Using the demographic and economic variables, and that's where Mr. Palmer, you're saying that you might divide up your different service territory differently, and then that makes it, you have to suddenly be running weather normalized sales forecasts for your 3 different areas?
Madam Chair, my concern on this is that we will be back in front of the commission and saying that our study was not extensive enough to do it. We're fine to try and do Order 205, but then when the bar comes up and it says you didn't do it to the level of a professional.
Well, maybe if you meet with the department ahead of time, like they're recommending, you could discuss it in 213 too. But maybe I'm just getting a little frustrated here where it's like, Commissioner Tuma, will you help me out in your overall motion? You're thinking you should do 205 or portions of it then with
What I
your
was
2
suggesting
cents?
is that we would, as part of the compliance process, to send 205 and 217 C and D to the company to work with the department and OAG to come up with appropriate weather and economic demographic information for the next rate case, and that if there's no objections to whatever the company comes up with, the executive secretary will then pass it as what the order would be. So it's negative checkoff
For the future,
future, so we don't have
but
to
it would be weather
come back to us
normalized
for us to
later.
deal with it, yeah. But it would be then in there, in an order that they must do for the next rate case. And so everybody's on the same page, so we don't get this mess that we got right now.
Okay,
That's what my thinking
sounds
is.
good. Commissioner Sullivan.
That sounds like a good way forward, Commissioner Tuma, on that. I mean, I don't know what is going to be in your motion, Commissioner Tuma, with 205. No, not 205, sorry. It's, was the department's decision option to get 9 months ahead, which one?
213.
213. I mean, I heard the company like not wanting to, they want to be more flexible, but I'm just thinking about what Ms. Arnold said. I mean, I think I'm totally comfortable with the 213 language. I don't know what you're thinking about with 9 months, but I'm comfortable with that. I think that the company should know 9 months ahead of time if they're going to go into a rate case. And I think that the department makes a good point that they need to be able to analyze this and get ahead of things. And one of the things that we found right now is that there are little issues that are bubbling up that I think should have been nipped in the bud beforehand. And I think that those, having a little bit more time is going to go a long way in addressing that so that we don't have to have this, have this going on right now. So that's, I kind of like 209 as it is, or I mean 213, sorry, I keep mixing up the decision option. So whatever you do, I just wanted to let you know that before you do it.
The only other questions I have, Madam Chair, and just whether you guys have it, I can tell you what I'm thinking, and then if you have questions to the parties, you can certainly ask them, but on kind of the more financial issues, volume 201 and 203, those two decision options, which are the forecasting, I actually agree with the company on the residential estimate is appropriate. I understand what the department and OAG were, well, the department in this one, were concerned about. But I think there's enough historical on this that that's the fair one. So I would have moved, if I were to move, I would move 201. I do agree with the OAG though on 204. And I think it's a fair proxy to do the 990 that Mr. Cherney emphasized in his opening. So when I said I can agree with everybody on their priority statements on opening, this is one I agree with Mr. Cherney that a fair proxy here is the 990 that they have come up with. It's not accurate, it's not real, we know that, but we don't have the information, and it's fair that we at least put some proxy in there instead of just denying it. You did that here, and that makes sense. And so if I were to make the motion, I would do 201 and 204.
What parts of of A, B, or C is that?
That's all of 204, A, B, and C would be all of that.
All of it, okay. And then we talked about the other motions, or you talked before, so it would be 201 in the volume 2. You would move 204, A, B, and C. Your
Might want a few
negative
minutes on
check off for 205.
just to make sure Ms. Kaylor is good with whatever language we come up with. And then I would move 209, 211, 213 with whatever number Commissioner Sullivan and you guys are comfortable with. And then I would move 215, first sentence, not the last sentence. And then I would move my 217 new, but a C and D would be part of the negative checkoff. We need to do some drafting.
Commissioner Partridge.
Can you go back to, you said the first sentence of which one? Sorry.
215?
15.
Okay.
Just the first sentence.
I think that it feels really ridiculous to require you, Mr. Palmer, to meet with the department ahead of time to discuss how to file a rate case when you're hiring like a firm that does rate cases in front of the commission all the time and knows how to run a rate case in front of us. So I'm supportive of 213 because I'm sympathetic to the like, you only come in every 15 years, but when you do come in for a rate case, you know what to do to like file a accurate rate case and avoid errors and we want to handle it as expeditiously as possible and hope that it results in a settlement where everyone thinks it will result in just and reasonable rates. But I'm supportive of Commissioner Sullivan's point to you need to meet with the department ahead of time just to help not have all of these problems that have bubbled up here. And, it's a little bit of exhausting for us to see the things that shouldn't have been this hard have been hard. And I understand from your company's perspective, this is increasing the costs to run a rate case, but it's also well, you got to know how to do a rate case accurately. So not just accurately, but in the manner that will result in a expeditious outcome too. So I'm supportive of Commissioner Sullivan putting in 9 months ahead of time with that understanding. You meet ahead of time, you may not know it's exactly 9 months before you're going to file, but if hopefully we don't see you for another 15 years, and a year ahead of that or 9 months ahead of that, you give a heads up to the department staff and others that you're going to do it in a way that makes it easier on everyone. Does that kind of work for your understanding of how this should be? Or
And if you claim 9 months is unrealistic, what is realistic?
Madam Chair, Commissioners, I'm fine meeting with the department. The issue for the company is we did not plan to file a 2025 rate case. We have tried to put that off. And what happened is 2024, there was no grain drying, it was very warm, and we missed some of our bank covenants. And we saw that in June of 2024. And part of our commitments to restructuring the financing of the company was to file a rate case for rate relief. And we made the commitments to the banks to keep our company financially viable.
That was 4 months.
It was 6 months before the test year went in, but 4 months before the rate case. We have to get through January, February, March to know if we're dealing with that kind of situation. I'm fine with 9 months, and it seems like we ought to know, but we've really tried to stay out of the rate case. But what we will do is we will meet with the commission staff and the department annually and say, we might have to file a rate case. What are the issues? And we'll try and get these details worked out so you don't have to. I understand that, and we accept responsibility for that. So I'm fine with the order as it is. We will operate within those constraints.
that sounds good to me in terms of Commissioner Tuma, you want to modify
We don't have
2/3?
to do anything. I didn't make a motion yet, so
Oh,
I
okay.
don't have to modify anything. But I will modify stuff if you need me to.
Yeah, what's your motion then? Unless,
My motion, if I were to make it, Madam Chair, which I will be happy to do, 201, 204, 205, modified so that it's part of the compliance filing that they need to develop these forecasts in agreement with the department and OAG, or in consultation with the department and OAG.
and use weather normalized sales.
Yep. So how this is the how, not they're gonna, it's just how. Okay, to make sure that they're not having to go and hire some expensive expert. Okay, that doesn't need to be in there. I'm just making an editorial statement. And that,
Big Texas.
if there's no objection within 30 days, the executive secretary will be authorized to approve that future rate case, weather normalization, demographic and economic data obligation. And that also includes Tumanu 217 C and D under that one, okay? And then I would move 209, 211, 213 without any changes.
Without any changes?
Yeah, because the 9 months is in there.
Oh, I thought, okay.
So I'm not making any changes to the staff briefing paper. And then 215, just the first sentence, okay? And then to Manu 217, A, B, E, and F. The parts that are not part of the negative checkoff.
Okay, so I was thinking that 213 would say something like require GMG to meet with commission and department staff annually.
I think they just said the natural outcome of this is going to be they'll have to make annually if they're going to have to do a thing in 9 months. That's what they said. So I'm just going off what they said. It'll.
Yeah, but I thought you were moving 213, which
And
says,
213 as it is, which will, in practical, what they're saying is practically means you're going to have to be meeting with them every year.
okay, I just heard Mr. Palmer say like, they don't always know 9 months before if they're gonna file. And so if we put a requirement on that they have to, I don't want there to be like a 9-month clock where they can't file because they haven't met with, as our order said. I'm just not jiving with what you're saying. I think we're trying to get at the same point, which is they should meet annually with the department and our staff to discuss any potential future rate case filing.
Want to say that, Madam Chair? That's, I think, practically what 213 says as it says right now. The other, by doing it saying annually, well, what does that mean? Do I meet with them one day before I file the rate case? And so I think what the department was trying to say is, we would like to have some time frame. And so that's why I asked the question. And Mr. Palmer said 4 months would have helped them. They could have met 4 months this time around. And so what I was going to suggest is let's just do 213 at 4 months, okay, as opposed to the annual requirement. And so that's what I was thinking, but then you kind of locked into, Mr. Palmer says we'll do it annually. So
No, I'm
I'm
fine
okay with
with
whatever.
4 months. I just don't think there should be like, you can't file before 9 months because you didn't meet. And so that,
How do we do this? How would we just break, then I can make sure I got Ms. Kaler understanding my checkoff, and they can discuss which one they want. Because I don't care, if they can agree on which works better for them, then we don't have to sit here and have this painful conversation.
sounds good. The commission stands in recess for
So when you call us
10
back.
minutes, or
Was that
5
used to
minutes.
say in the legislature?
Yeah,
At the call of the
At the call
chair.
of the chair.
The call of the chair. Did you get it? I think I got it. Okay. If you got it, then I just want to make sure, because I was rambling. Tell them to come. Tell them to go get a table for us. Oh, sorry, it is on.
He spent some time in the Boy Scout too.
I have been in the Boy Scout. I've been in the Boy Scout. I might have actually commander probably.
The commission will come back from its recess. Mr. Swanson, did you reach an agreement or have any language you want to recommend?
Madam Chair, we did reach agreement and we would replace 9 months with 6 months.
I suppose it's an agreement, so
It's an agreement, so therefore, if the nature of it is that we are not waiving, well, whatever, the Commissioner Tuma, why don't you fold that into your,
I would fold that into their agreement to do that in advance will be memorialized very clearly in our order. And then also one minor change, Madam Chair, in 204, apparently under 204B, 185 is repeated. It should be 184, 185, and 196 under 204B. So the first one is 184.
any discussion of Commissioner Tuma's overall motion, and is it clear to commissioners? All in favor of Commissioner Tuma's motion, please say aye.
Aye.
Aye. Opposed, the motion prevails. Cost of capital. So, Commissioner Tuma, we have a lot of agreement in here and some that, where there is not. But could
Madam
you
Chair.
start off with what you were thinking?
You know, I'll tell you kind of what I'm thinking right off the get-go, and that I would agree with, the 301, 302, 303, 304 are all pretty straightforward. I might indicate that 308's fine by me, okay?
Wait, sorry, you're too fast. 301, 302,
303,
303, and
304, which is for this rate case only, and I'm sure Ms. Kaler would make that point. I don't want Mr. Swanson coming back and arguing this in another rate case. And then 308, which is 10%. I agreed with the ALJ's logic behind that. I would agree that there's no need for us to talk anything about proxy groups, so 313. I agree the same with risk factors, so 316. Here's where it would get a little more complicated is flotation. I actually agree with the department, and Mr. Adonisio and I are finally thinking along the same lines on flotation. It's good to see that. But I would think that flotation is very speculative based on the testimony of Mr. Palmer and when he testified in his rebuttal. It just seems still very speculative, and they have expensed out some of these costs anyway, so I don't think flotation belongs in the ROE number. And that's where I agree with the department on this and disagree with the ALJ, and so that it would be continuing the ROE at 10%, but not giving the 15 points.
And then Commissioner Tuma, for 318, I'm just not tracking what you're thinking. You're saying that the record doesn't support a flotation cost adjustment in this record only.
In this record only, yeah.
And so you wouldn't adopt A, B, C, or D?
I don't necessarily need A, B, C, or D. 318 is sufficient for me, and I know Ms. Kaler would be able to put the order together. So 318 is all I would do. And then 321, of course, the executive secretary has to come up with a new cost of capital if we make that adjustment. So that's what I'm thinking. I don't really have any questions for the company or the parties. That's just my thinking on the record is very clear on this, and so I don't need to ask questions, but I'm certainly willing to.
Well, Commissioner Tuma, I've been working with you long enough to sort of guess that ahead of time. I was thinking that's where you would land. And my question then for you is, and I'm of the similar, or been through enough of these to, like, my mind gel a little bit with you, but if we don't give them a little bit of an upward adjustment on their ROE, but I thought there was enough evidence in here that, and I agree, we don't need to do a specific flotation cost upwards adjustment, but I guess I was just sort of thinking in my head, based on the record and reading and the different parties' proposed numbers, that we'd get, if we didn't do flotation costs, the 10.0 would be a little tiny low on the record. That instead, I was thinking like we could, if we don't adopt flotation costs, there is enough support based on the charts that now I don't have in front of us to get the 10.0 ROE a little higher, like up to 10.05 or 10.10, but not, not also adjust. Then also, I agree, we shouldn't specifically allow an adjustment for flotation.
I would agree with you, Madam Chair, that there is sufficient evidence in the record for us to do essentially anything between the department's recommendation of 6, whatever there was, up until somewhere in the neighborhood of, 10.25 or whatever, something. I mean, it's just enough evidence in the record. You have flexibility, like we've had discussions before and found a number, So, yes, I agree with you that there is room for us to move. I was comfortable with their 10.10 that they came into. They didn't have a lot of evidence for it, but they said, hey, let us stick where we're at, and that's what makes me comfortable to go with that as opposed to trying to push
And
it
it's
down.
in the range of what the department.
It was definitely
later
within the range, and
recommend.
I thought almost squarely in the middle of the range, and so that's why I was just comfortable with just going with it. But this is not a judicial decision. It's kind of a policy, legislative type decision that we can make because we're definitely within the range.
Commissioner Sullivan.
I guess I was, I was thinking we're in an environment where interest rates are going to forecast to kind of trend downward. I saw it as within, the department's analysis, both the 2-stage and the 3-stage. There's obviously differences between the two, but, I saw the 308 at the 10% ROE is kind of that just felt right to me between the different types of analysis. I think, we are pretty clear we're not picking any one single model over another one. So I kind of looked at it as, okay, this feels like the porridge is just right. So that's where I was at with
Sorry.
the 10.
With the 10, that's where you landed too?
Yep. And I think the company said at the beginning, didn't you say you were okay with the 10? Did you say that or no, Mr. Swanson? Or you want a little bit higher, I'm sure, but.
Madam Chair, Commissioner Sullivan, I think I was careful in my words that we supported the 10.0 ROE and the 15 point because the 10.15 was still conservative.
Yeah, okay, yeah. You were careful in your words. I wasn't careful in my hearing. So I still am where I'm at. So I was comfortable with, I just thought 10 felt like the objective analysis provided by the department on the record, could support it, and just kind of knowing where things are at, I was okay with it.
With no flotation,
Right.
then?
No. Yeah, I think we don't, as a commission, we say flotation is included in there. It's inclusive. You get the number you get and floats in that. Am I saying that clearly?
Mm-hmm.
Okay.
Okay. Anyone else want to weigh in here? Otherwise,
She doesn't look
Commissioner
like
Tuma
Audrey.
made a motion, or did you make a motion, or you said you would make a
That would be my
motion?
motion would be 10, yeah.
And again, you didn't pick a single model because, and just so I'm continuing to mind meld, our order though could reflect that normally we have relied on the discounted cash flow, the two growth one. And because I do think that is, while I appreciate like the department's additional modeling here, I do think like we have to continue to,
Want to emphasize that, Madam Chair, we could modify 304 and just say, for this particular rate case, because of the size of GMG or something along that lines, but I don't feel a need to do that, because I know the order writer recognizes because we're not picking a model, she would probably point that out, and Mr. Swanson on the record has said he recognizes that, he's not going to use this against me on CenterPoint's rate case, so.
I think Mr. Swanson said the two growth model is what is the most appropriate actually, right, Mr.
I
Swanson?
might hold it against him this time a future rate case, but.
Madam Chair, Commissioner Tuma, you're both sort of right on this one. Yes, I did state that you have a very, very long, consistent history of the two growth, but I agree actually on this one that you don't necessarily need to specify because you're not going to peg the number to any analytical result. If the commission wishes to restate its historic reliance on the two growth, I think that's fine as well. But in this case, I don't think you need to peg it to one.
And Commissioner Tuma and Commissioner Sullivan, I appreciate the recognition that the way we handle flotation costs is the way we'll continue to handle flotation costs. But just like giving you one more chance to, like, do you want it a little bit higher? Because the overall recommendation from the judge was 10 with the 15 flotation tacked on. So, like, I'm fine with your motion the way you said it, Commissioner Tuma, as long as we don't see another rate case for 15 years. And that's where I'm just like, it's just like weighing a little bit of balance to ensure that we're fully reflecting the company's costs so that we're not making like an error in judgment where we later then are back looking at another rate case sooner than we thought.
I'll
But
put it this way, it was very hard to me to get to double digits on an ROE. So, I mean, that's why I was comfortable with 10, because the parties, the company had kind of agreed to it and brought it, and I didn't think the record moved me off it, but, I mean, my natural inclination would be to drive it down to, 9.9 or something like that. I just have a hard time having Minnesota's name tied to it, ROE that's 10 or over, but I was comfortable here given the small size of the company and their willingness that was where they were at. So that's why I'm kind of stuck on 10.
I guess, I mean, I think this is very much more of an art than a science, but the modeling that we have in the record shows a range. So my feet are not fully in concrete at 10. But, I think that the point that Ms. Arnold raised, like, this is a company that is, you're well managed, you're doing a good job, you're running a good company, and your actual ROE is above, 10, means you're managing things. Mr. Swanson wants to, let me finish my thought. But, like, you're doing a good job. And when I look at the record, I was just like, 10 seemed to be a good number to me, between the different ranges of, what we see between the different models. And I was comfortable with that number. So, I guess I could go to 10.1 I could go to 9.9. I'm like right in that spot, but for me, it all feels about the same. Mr. Swanson?
I think if I could just point out, my understanding of the record is that which I normally look to, the 2 growth DCF, table 308, if I'm reading it correctly, in the page 13, which is the department SIR rebuttal, is if we went to like 1010 or something, it would still be within the range of the mean low ROE the department recommended and the mean high. But that was where I was kind of, but I'm fine. My feet are not in concrete, Commissioner Sullivan. So, like.
I use that statement.
I know, that's why I'm. Mr. Swanson, I think Commissioner Sullivan asked you a question.
Yeah, Madam Chair, Commissioner Sullivan, thank you. Just to make sure that the record is clear, the company's historical ROEs from 2011 through 2023 are in the record. Mr. Palmer provided that in his rebuttal testimony, his table 2. And what it shows is that in 2 years, the company was above 10 out of that time span. And then the 2024 jurisdictional annual report was filed since this table was put together, that you have here at the commission. That was 6.86. I just wanted.
Eyes need to pop out when he said that, so I don't know what you're.
Yes, thank you, Chair Sieben, Commissioner Tuma. Lawyers aren't great at math, but I did, in fact, I believe it was in the department's reply brief, provide the math there. So, and I was also, like Mr. Swanson, very careful in my opening remarks to be accurate. And then again, when I was asked for clarification by Commissioner Sullivan. So as I previously stated, there were 2 years where it was above 10%. That's 11.9 and 11.7%. And then when you average it over the 5 years, the average is over 5%. So I want to be very clear, I was not making any misrepresentations.
Average is over 10%, you said.
Okay, Commissioner Tuma, you had a motion. It sounds like that's where we're landing. So if, is the motion complete too? Did you do all of?
I think I got everything together.
Any other discussion on Commissioner Tuma on your motion for the cost of capital? Otherwise, then Commissioner Tuma and Ms. Killer, you have it. Okay, the motion's clear. All those in favor, please say aye.
Aye.
Aye. Opposed, the motion prevails. Volume
4 is real fast.
4. Do you have a motion, Commissioner Tuma, with your revised 405C?
Yes, Madam Chair, I would move 405 A, B, C is modified by myself on the attachment, and E.
You would move your 405C.
Yep, along with 405A, B, and E as they are in the staff briefing papers. And then I would move with that 409, which is ignore the past rate cases, only go with this rate case as far as your filings on class cost of service in the future. And then I have also 410, which is kind of our standard language, which we don't adopt any specific class cost of service study, but thank you for all your work in doing the class cost of service studies. They were helpful. So that would be my volume 4 motion.
And we did give parties opportunities to provide comment at the beginning, but we didn't really specifically hear if there were objections to any parts of this. So
That's correct.
Do Mr. Swanson, any comments?
Thank you, Madam Chair. No objection from the company on new TUMA 405C. It's helpful to have this memorialized.
Now, we left a lot of things out the department and OAG asked for, but our staff, in conversation with them, we felt like this give us the bulk of what we need up front. And so unless you think there's something else in the other letters that are absolutely necessary, that we should have in the order.
Thank you, Chair Sieben, Commissioner Tuma. The department, would still prefer our original decision options, but we're not going to lose a lot of sleep over your proposal if that's what ends up going through.
Mr. Cherney, any comments on the motion or the,
Chair Sieben, no, we're in the same boat as the department.
okay,
And I didn't do 404, Commissioner Sullivan was wondering about that. I thought my 410 covered that essentially, because I'm saying in 410, we're not necessarily, we could do 404 and 410 would work together, but I think 410 is inclusive of the concept we're not adopting a particular.
but you can just put 404 in for clarity then for the order writer.
If you want it, but.
Sure.
It
doesn't hurt.
conflict. So
Okay.
Madam Chair, I would move 404, 405 as indicated the parties are okay with, 409, and then my 410.
On Commissioner Tuma's motion, is there any other discussion? All in favor, please say aye.
Aye.
Motion prevails. Rate Design, Volume 5. And
Chair Stephen, I hate to interrupt. Because we have to go to the first floor bathroom, I'm wondering if we could take a little bathroom break.
sure,
Okay.
you could do it whether you were going to the first floor or this floor, but it's fine to.
Fine.
Chair, where's
need a
the court
break.
reporter when you need that memorialized?
For the record,
The commission stands in recess until 1 o'clock. The commission will come back from its recess, and now we're on Volume 5, Rate Design. And Commissioner Tuma, did you want to start with questions, or this is our last volume, too. It includes housekeeping
Land
and,
this plane. Just rationale for, I think you all saw my 501A. Rationale was there to try to keep things simple, because a lot of the apportionments are bouncing all over. So, you know, I think it works within the class cost of service studies. I'm comfortable with it, but my thinking was large interruptible class. You indicated that going to 9.9 made sense, and you had some concerns about losing these guys to other customers. I got that, but you were saying 9.9, so I was comfortable with taking interruptible AG1 class to 9.9 as the company suggested. And then the commercial and then the industrial and the other interruptible client, I thought they get their bill, they're going to look at it, and they're going to say, has my rate increased? It won't. The only thing that's going to change would be the fixed charge that you suggested in your recommendations. And then arguably any of the money, I call it savings, it's not really savings, any of the money that's not covering your revenue requirement would be covered then by residential and small commercial, which should cause residential and small commercial, depending on how all the numbers worked out that we discussed today, to go down probably somewhere based on just, again, somewhere below 6, maybe just barely or something along that lines, so that they would then be the only ones entitled to a rate refund. And so that's my rationale for doing it the way I did, to keep it simple. And then the small commercial and residentials will see a not insignificant, but a small reduction in their per therm charge going forward, and then they would also get a refund. So that's my 501A. Company concerns, thoughts?
Thank you, Madam Chair. Commissioner Tuma, no concerns. I appreciate the explanation, and we appreciate you taking the time to put it out in time for us to look at it and consider it, and we think it is workable.
DOC.
Chair Steven, Commissioner Tuma, the department does not have any concerns with your decision option 501A.
Mr. Turney.
Chair Steven, Commissioner Tuma, obviously we still have our preference, but
Right.
we understand where you're coming from.
So, Madam Chair, my decision option, I would move that 501A. Along with that, I would move 504, okay? That's adopting the fixed charges. I kind of talked about it in my motion, but I just make it very clear. The fixed charges will go up as the ALJ and GMG recommended. And then I would move 5. I don't think we have to do anything on the reconnection fee. I don't think I want to do it, is what I'm saying, okay? But then 509 or 10, I don't think we need to do, because I'm suggesting we not do that. That's additional reporting. But then I would do 511, which is the late fee. This was agreed to by ALJ, or approved by the ALJ in the department and GMG. So my decision option would be my 501A, 504, and 511.
because essentially I had circled 508, but you're essentially allowing them to continue to charge their same reconnection fee?
Correct. I don't think we need to do anything here
Okay.
because it's already, we would have to do something if we want to change it. And so I didn't feel a need to say continue to do what you're already doing.
I support your motion. Is there any other questions or discussion? No? All in favor of Commissioner Tuma's motion, please say aye.
Aye.
Aye. Opposed, the motion prevails.
And lastly, Madam Chair, we have 901 through 905, and I don't think we need to make any adjustments. I'm looking over at our staff based on the thing we've done. So unless the parties have any objections to 901 through 905, they're the
Ms.
standard.
Palmer? I mean, Miss Arnold, Arnie Palmer, I don't know where that. Like I'm thinking about lunch.
Very
I apologize.
Chair Stephen, thank you. I think the department was interested in having 60 days for the compliance filing, given that it might be more of an extended discussion about the weather issues and the economics back that we were talking about for the sales forecast. So just to ensure that the parties have enough time to have discussions, explore options, just a little bit extra time there, given everything we have going on, would be appreciated.
Any concerns from the company?
No concerns with the 60 days, no. I think the only issue on this set that we paused on just because it hadn't been discussed was any change in the CCRC in 902C. I know this is language that's been used with other utilities. There hadn't been any discussion about the CCRC. So we're wondering whether that was really necessary going forward or not.
I would be looking at our staff or OAG or the department if they have any concerns. Tell me what the CCRC is, then that'd be
Madam
even
Chair.
better.
Madam Chair, Commissioner Toomer, Conservation Cost Recovery Charge. And we were just confused about it because it'll sort of be zeroed out at the end of this summer, but Ms. Campbell suggested we put in the compliance that we will not have a change, and that works.
So you just keep C as it is, and you'll just say, no change. She's nodding her head, but
If it works for Ms. Campbell, it works for us.
well, definitely I'm not going to argue with Ms. Campbell on that one.
Are you talking, Commissioner Tuma, are we talking about 9022B,
We're
the
talking
schedules?
about 902C.
A, or C under 2? Oh, no, C over here.
C, straight C on the second page.
Oh, I see it now.
26.
Okay.
So
So
apparently
can we
that
just say
CCRC
like as appropriate or something?
I think we can say that as appropriate.
Ms.
Ms.
Keeler
Campbell says
got
it'll
that.
work if they just say nothing, so
So you want it included in your motion?
she seems to be, it's going to work.
Take it all out?
No, leave it in, and they'll file some saying there's been no change, and they'll be okay with it. Or 0 or whatever, I don't know, something like that.
So for
apparently it's okay.
902C, do you want it included in your motion or not?
I do.
To
It's not a
say
problem.
what?
Say what it says now, and it'll be not a problem, is what I'm
Okay.
hearing from them.
Ms. Keeler, are you clear on the motion, the overall motion? Any other discussion? All in favor of Commissioner Tuma's motion, please say aye.
Aye.
Aye. Opposed? The motion prevails. I think that's it, everyone. Thank you very much. If there's nothing else, then we are adjourned. Have a good weekend.
Thank you, Madam Chair and Commissioners.
Thank you, guys.
Thank you, commissioners.
Thanks for using WebEx. Visit our website.